Alrighty, good evening, everyone. Welcome to week 10 of constitutional law. Hard to believe we're this far into the term already, but here we are. This tonight we're talking about express rights in the Constitution, and it's an interesting topic, and it's one that maybe some of you will be shocked at the limited extent of express rights protections that are in our Constitution. Maybe some of you already knew, but if we think back all the way to week one, where we talked about some of our ideas and conceptions of the Constitution, and it being this really important document to protect rights, and to an extent that is true, and it does do that, but it's an interesting and some people sometimes find a bit of a confronting week, to realize how limited the express rights protections actually are. What we're going to do tonight is talk through a little bit more exam prep, and building on some of the things that we've been talking about in other weeks. Then we'll talk through structured proportionality, and how you can think about that, and how you can reconcile some of the competing views about structured proportionality and its use and relevance. And then we'll work through our tutorial questions for tonight, and look at some of these express rights in action. But I suppose I wanted to start tonight just talking about the exam, and in particular thinking about, we've talked in previous weeks about preparation and note taking, and building up your notes to a point that they'll be really useful for you in the exam. What I wanted to do tonight was talk about the identification of issues, and in particular being able to recognize, as you read through the exam scenario, being able to recognize what the question is asking of you, and being able to make sure that you're capturing all the issues that you need to talk about. And the reason that that's important was that one of the things that some people probably could have improved on from the midterm assessment was that identification of issues. And don't get me wrong, most people did a great job of identifying the key things that they needed to discuss. But there was a group of people who, let's say for question 2, you're given the question, which international heads of power might support the legislation, and they only talked about defense and they didn't talk about the external affairs power, or they only talked about external affairs power and they didn't talk about defense. And so that says to me that there's room to improve, and even the people who did manage to identify both, it doesn't hurt to make sure that we're our skills in identifying issues are sharp. So there's room to make sure that we're being strategic and careful in the way that we're identifying issues, and making sure that we're identifying all the relevant issues. And so the reason that could crop up in the exam, let's say, is, you might get a question on the exam, you'll get the scenario, and then the question on the exam is, the hypothetical client is interested to know whether any of their express rights under the Constitution have been affected, or whether this particular piece of legislation infringes any of their express constitutional rights. And then it's up to you to be able to identify, oh, okay, is this a potential Section 92 issue? Is this a trial by jury problem? Does this infringe on the freedom of religion? And so just being able to make sure that you're being able to accurately identify that is really important, because if you miss something, then there's a whole chunk of marks that follow on from that you miss out on as well. So how can you make sure that you're doing that? We've talked previously about making sure that you're spending enough time in the exam at the start of the exam, giving yourself enough time to sit down and plan out your answer. In an assignment where you've got a lot more time, you've got more time to be able to sort of sit with it a bit and consider yourself your answer. But in the exam, the temptation is to feel like, oh, I've got such a limited time. I've just got to dive in and start writing straight away. And I'm just going to say the first things that come into my head, and I'll just ride the train or the roller coaster that is the exam all the way to the end. But when you do that, there is the issue that you don't, that you miss something, or there's the risk that you miss something. So one piece of advice that I would really emphasize is just making sure that you take the time at the start of the exam to map out the answer and read the question a couple of times to make sure that you've captured everything that you think needs to be captured, or captured everything that is potentially relevant. The other thing that you can do is to, I suppose, approach the question from the other direction. So you'll have your kind of your list of potential topics. So state and Commonwealth judicial power, express and implied rights, and constitutional change, and then the sort of the sub issues within that. And just if you've got your short form notes in front of you, it won't take very long to just quickly flick through each of those and think, oh, could this apply? Is there any way that that state judicial power is being affected here? No. Okay, I'll move on to the next one. Okay, is interstate trade or commerce affected? No. Okay. Is there a trial? Is it a criminal matter? Is there a trial by jury? Oh, okay. Yep, there is. I'm glad I've found that, and then move on to the next and move on to the next. So almost using your short form notes as a bit of a checklist to make sure and satisfy yourself that you've identified everything that you can possibly talk about. And then you can budget the rest of your exam time accordingly to make sure that you've got enough time to talk about each of them. And then the third thing I'd say is a really good familiarity with the material. If you're well prepared and you're across the nuance of the different cases and familiar with the different topics, as you read, the facts should leap out to you and should tell you, oh, you need to talk about this, oh, you need to talk about that. And I think that for the obvious things, that's, those leap out easily. Where you want to be careful with it is making sure that where there are smaller details that can indicate something important to you as well, making sure that you're prepared enough that those smaller details leap out to you as well. So just, those are some general comments about making sure that you're in a good position to be able to identify the relevant issues and the relevant things that you need to be talking about. One of the things that potentially you'll be talking about is express rights and the different express rights that are provided to us under the Constitution. One of the things that I do want to spend a bit of time talking about is structured proportionality, and specifically the way that structured proportionality has crept into Section 92 jurisprudence and how we resolve the apparent mess that's popped back up in relation to Section 92. So by way of background, and some of this is covered in the lecture materials and your textbook, but just to reiterate it and to summarize, prior to Colin Whitfield in 1988, the Section 92 was the most litigated section of the Constitution. There'd been something like 140 cases. It was a complete jurisprudential mess, really, quite frankly. There was just so much hand-wringing and judicial angst over what absolutely free means. And then Colin Whitfield was celebrated as this consolidating way of consolidating all these divergent views, and I think that even though it wasn't necessarily the best, or it was a test that maybe could have been perfected, I think everyone was so relieved that the court had been able to settle on something that the Colin Whitfield test just sort of stuck. Until Palmer and until we hit structured proportionality. And so in parallel to thinking about Section 92 and all the mess that historically has come with it, you'll remember sort of, we talked about it mostly in week one, but it's been an emerging or enduring theme throughout this unit. This idea that the Constitution is always in movement, and that there's these sort of legal ideas and legal problems within the Constitution sort of slide in and out of fashion. So, a lot of the very early cases focused around Commonwealth and state relations, focused on setting up limits of power of the different institutions. Last week, when we talked about state judicial power, and in particular the Cable Doctrine, that was the kind of the in fashion issue throughout the 2010s. And then from the sort of the mid to late 2010s and then through to now, structured proportionality has been like the thing that the High Court just can't quite seem to agree on. And so where that leaves us with Palmer and with Section 92 is a situation where technically the use of structured proportionality in relation to Section 92 is the current law, or the best way of understanding how Section 92 should be interpreted. But we've got this sort of caveat that structured proportionality as a judicial method or as an approach is not well accepted by all the members of the High Court, B, not well accepted within the broader legal community. But even beyond that, the High Court itself is changing. Chief Justice Kiefel, who has been the strongest advocate for the use of structured proportionality, retires at the end of the year. Justice Keane, who was sort of solidly with her on the use of structured proportionality, retired at the end of last year. And Justice Gageler, who has been probably the strongest opponent of the use of structured proportionality, is moving into will be the new Chief Justice of the High Court. And so we're at this sort of difficult tipping point where the use of structured proportionality is technically the best approach, or the current approach. But looking forward, it's not really clear that that's an approach that will necessarily hold. But it's also, something that may take years or decades to come back up as an issue and be retested. And so it's a type of issue that, for those of you who, I suppose, enjoy the nuance and the gray areas and the uncertainty of constitutional law, you probably like this stuff because it's something that you can really sink your teeth into some of these ideas. If you're the type of person who doesn't like the uncertainty that comes to constitutional law, this is the kind of thing that is going to absolutely just confirm your hatred of everything to do with constitutional law. And that's fine. You can hold those beliefs. And, I'm here to, I suppose, shepherd you through that and help you navigate that as best as you can to just, survive the current constitutional study and the constitutional climate. So where does all that leave us? It means that when we're thinking about Section 92 issues at the moment, we have to know about structured proportionality, and we have to be able to apply structured proportionality to Section 92, because that's the current approach that the majority of the High Court used in Palmer. But it's also important that we're very conscious of the previous approach developed under Colin Whitfield, because we can't remove the possibility that won't be the test moving forward, right? There's a strong chance that the next opportunity it gets, the High Court moves away from structured proportionality and moves back into something that more closely resembles Colin Whitfield. So we need to be conscious of and aware of both of these tests and both of these approaches. To cap it all off, in practice, the distinction may not actually matter, right? Potentially both of these methods lead us to the same conclusion, and we'll probably see that in today's tutorial. But it's important that as an exercise in legal reasoning, we're able to communicate those different approaches. So I've done up a little bit of a flow chart. I thought I've done a lot of lists for people who prefer something a bit more visual. I've done up a flow chart this week for structured proportionality. Now, this is something that is obviously important to us this week for Section 92, but it's also going to be important to you next week for implied freedom of political communication. So I've left it topic agnostic, so that you can apply it to both. And the idea is that the method is the same. But basically what we're doing with structured proportionality, firstly, we're looking at the law itself. So the piece of legislation that Parliament is passing in Palmer, the Emergency Management Act. Next week, when we're looking at the implied freedom of political communication, it will be various bits of legislation that restrict free speech. But this bit of legislation that's under challenge, and we're trying to do two things. Firstly, we're looking at what the purpose of the legislation is, or what it's aiming to do, the effect that it's trying to produce. And then secondly, we're looking at the burden. So what's the right or freedom that's being impacted or taken away by this law, and how big is that impact? Is this a significant burden? Is it just a minor burden? So our first step is to focus on the legislation itself and think about, okay, well, what's it trying to do, and what do people have to give up in order for that effect to be achieved or realized? Then we move into the structured proportionality elements, and there's three sort of steps. So the first is to think about whether the law is suitable. So when we think about the purpose of the law, is there a connection between what the law is doing and the purpose that it says it tries to achieve? And if it doesn't, if it's not suitable, if there's no rational connection, then the law will be invalid. If it is, then we think about, okay, is the law necessary? And when we're thinking about necessity, we're looking at this question of whether is this the only option? Is there a way that you could achieve the same objective, but in a way that doesn't impinge on people's freedoms or doesn't have the effect that it seems to be having? If no, so if it's not necessary, if there is some reasonable alternative, the law will be invalid. If yes, then we need to think about whether the law is what they call adequate in its balance. So does the burden on the freedom, is that outweighed by the legitimate purpose that the legislation's going for? So does the good outweigh the bad, in essence? Does what's trying to be achieved, is that more important than the rights or the freedoms that people have to give up in order to receive that benefit or um, in order for that aim to be realized. If no, if that balance is out, the law will be invalid. If it is, then it will be valid, or at least it won't be, it won't breach the Constitution, right? It might, if there was an issue with the use of a head of power or something, that might be an additional problem. But in terms of this idea of structured proportionality, we'd say that the law is proportionate, it's adequate in its balance, and therefore the freedom or the right, the burden that's placed on it is acceptable. So that's structured proportionality. Running through that in terms of Section 92, let's use the Palmer case as the example, right? The purpose was to combat the spread of COVID-19 and to protect public health. And in doing so, it created a burden on people's ability to move in and out of Western Australia. So was the law suitable? The majority of the court found yes. There was in order to stop the spread of the pandemic, the advice from medical experts was, if you don't have infected people coming in, well, if you don't have anyone coming in, or if you limit the number of people coming in, you reduce the odds that someone with COVID comes into the state. And if no one in the state has it, then they're not going to spread it, and public health outcomes are protected. So there was a connection between the aim of protecting public health and stopping people coming into the state. Is it necessary? Was there a reasonably practicable alternative? This one was a little trickier to resolve. But remember, at the time, the evidence was that closing borders was showing up as the most effective way of reducing the spread, especially when cases were low. Stopping intake was demonstrated as being the best way of keeping those numbers down. So again, the court agreed that the law was necessary. And was the law adequate in its balance? And so the idea here isn't does it infringe on people's freedoms or not? It was never in dispute that that moving, stopping people's movement between state, it was never argued that wasn't a burden. It was accepted that it is a burden. The question is, does the legitimate purpose of protecting public health support imposing a burden on that freedom? And again, the court was pretty deferential to the advice of medical experts, was that in this instance that it was adequate, that the right balance had been struck, the public health purposes did outweigh the need for people to be able to move freely in and out of Western Australia. And as a result, they were willing to find that the legislation was valid. So that's structured proportionality. That's as I said, currently, that's the approach that we take to thinking about Section 92. So before we rewind and talk about Cole and Whitfield, are there any questions about structured proportionality and Section 92? No? Fantastic. I'll stop my screen share for a bit just to hold back the freezing Zoom as long as I can. So that's structured proportionality. That should be, if you got a question on the exam about Section 92, your first port of call should be a structured proportionality approach. However, I would be doing you a disservice as maybe potentially one day future constitutional lawyers or as anyone potentially affected by the Constitution. You need to be aware that that's the current test, but it may not be the test going into the future. And the test that we end up with down the line, it's possible that it ends up being something closer to the test in Cole and Whitfield. So you need to know that as well. And so the idea in Cole and Whitfield is that where the Section 92 prevents or prohibits laws which impose a discriminatory burden of a protectionist kind. So what does that mean? Again, we're sort of thinking about this in 3 steps. Firstly, we're looking at the law. Does the law discriminate between states? So is there, and that can be explicit, or it can be not outwardly stated, but in effect. Does it discriminate between states? Does someone in one particular state or a group of states suffer some kind of disadvantage compared to people in another state? So is it discriminatory? Secondly, thinking about, is it protectionist? And here, when we're thinking about protectionist, we're thinking about, does the law aim to preserve or protect some kind of benefit for the people engaging in trade and commerce in one state? So does the law protect traders in let's say New South Wales to the detriment or discriminating against people in Queensland or Victoria or whatever? And then thirdly, is that discrimination of a protectionist kind? And so when we're thinking about being protectionist, the alternate to that is that a law might discriminate, but for a non-protectionist purpose. So for example, when we think about Cole and Whitfield, the purpose of the law was to protect lobsters and maintain the healthy ecosystem and continued growth of lobsters. The idea wasn't to put people in different states fishing for these lobsters at a disadvantage. The aim was, let's protect the ecosystem and protect these lobsters. So we're looking at, first, is it discriminatory? But then second, is that discrimination for a protectionist reason or for something else? So the something else might be a legitimate reason. The idea under Section 92 is that the protectionist reason is not legitimate. And then the third thing is the if it's not for a protectionist reason, if it's for something else, is that appropriate and adapted? And so by that, what we mean is that law reasonably necessary? And so we're looking at some of the same ideas compared to, compared to the structured proportionality approach. We're weighing up, is this the only alternative, or could they do something different? Is there another way of achieving this legitimate purpose without resorting to discriminating between the different states or discriminating to the extent to which they do? So you think about Castlemaine Tuies, there was evidence to suggest that there was no reason why imported bottles and bottles made in South Australia needed to be treated differently. So looking at, is there an alternative? Could you achieve the same end without necessarily having to resort to the methods that are being used in the current legislation? So where does that leave us in practice? In practice, we're probably going to end up in the same spot. Whether we use structured proportionality, whether we use the test in Cole and Whitfield, we're thinking about the same things. We're thinking about what was the purpose of the legislation, how is it impacting on people's freedoms, and is that impact proportionate? Are there other options? They're the same ideas. We're just approaching them slightly differently and putting slightly different emphases on different parts of it. And it's the unfortunate reality of the place that we're at with the jurisprudence in this space, that you need to be aware of these slightly different approaches and methods. So we've got our tutorial question for tonight to unpack some of those ideas. But before we jump into that, are there any questions or comments about the Colin-Whitfield approach?
Yes, Jacob.
Yes.
I have a question concerning the individual's rights approach. So yes. Should we argue in three ways? First of all, to analyze this problem, whether the Commonwealth power to regulate trade and commerce is limited by Section 92 by using the individual rights approach, and only after that, free trade approach and the recent approach.
My preference would be that you start with the structured proportionality approach in Palmer, and then step back and look at the approach in Colin-Whitfield, and look at whether that approach introduces any differences to your conclusion. The idea of understanding the right in terms of individual freedoms versus broader collective ideas about freedom of trade. It's not, excuse me, I've talked a lot. It's not something that I would be looking for in the context of an exam. I mean, if you can fit it in, I'd be impressed. But it's not necessarily a level of detail that I'd be looking for in the exam itself. Those ideas around, do we conceptualize Section 92 as something that attaches to the individual or something that's more broad? I think it's useful for helping you understand the context for these cases, but I wouldn't necessarily be expecting a discussion of it in the exam answer. Any other questions? Fantastic. Well, let's have a look at this week's discussion or hypothetical question. And then I'll throw it over to you guys because my throat's going to give out in a second. So we've got Better Living, which is a company in Queensland, entering into a contract with Sunshine Unlimited to import margarine. The Queensland company make it in this weird truncated cone shape, but New South Wales require that all margarine come in cube-shaped blocks. So the New South Wales company applies for a permit or looks for an indication whether they'd get a permit to get this non-cube shaped packaging approved. They're told that would be unlikely, and so the contract falls through. They then start proceedings in New South Wales in order to test the constitutionality of that legislation. And in particular, we're curious about whether Section 92 has been infringed. So I'll throw it over to you guys. I'm interested in your thoughts about your initial reactions and where you'd start with this question. So let's start with Palmer and these ideas around structured proportionality. So our first step being to look at the legislation itself what's the purpose of this legislation? Actually, I'll keep my screen here. What's the purpose of the legislation, and what's the burden that we can identify?
So the legislation would be to protect the New South Wales consumers to be able to identify the margarine, so they don't pick up the butter.
Yep, absolutely. So,
Can I just add? Should we be limited in our conclusion that the legislation is to prevent confusion among consumers in using certain products?
As in, should we be looking for, let's say, ulterior motives in why New South Wales might have passed this law? Is that what you mean?
Yes. Isn't it a legitimate object? Prevention of confusion among consumers, irrespective of the state they are in.
I'm not quite sure. I'm completely following. So you're saying, it shouldn't be the legislation's purpose for protecting New South Wales consumers shouldn't be limited to protecting New South Wales consumers. It should be just protecting consumers all around Australia. Is that sort of where that argument's going?
Yes, precisely.
Meaning,
whatever the traders are, they are restrained by the shape of the packaging.
I can see where you're going with it. The difficulty is that the new, as a matter of federalism, the New South Wales Parliament is only responsible for and accountable to the people of New South Wales, and so it's less about, I think the argument would be that if the legislation was going to be, we want to protect consumers all over Australia from identifying the margarine from the butter, that would be a legislative overreach on the part of New South Wales, because it's not really within their jurisdiction to be dictating how people in South Australia or Western Australia are, what shape their butter or what shape their margarine comes in. So in terms of whether the purpose is legitimate, the goal for protecting consumers, and in particular, what I think sort of sells this as well is this idea that that New South Wales, people in New South Wales are somehow used to margarine comes in cubes. That's how they identify it. That's how they know it. It's this deeply rooted habit, apparently, of people in New South Wales. And so the purpose of, if a customer in a New South Wales supermarket or whatever picks up a cube of something, they're expecting that it's margarine, and they should be protected from packaging to have that expectation realized or satisfied, I suppose. That would be the argument. And in terms of whether that's a legitimate purpose or not, there would be a deferential approach to say that, that's okay. It's weird in terms of like stepping back from the hypothetical scenario. It's obviously a bit bizarre, but in itself, it's not necessarily something that's that you'd expect to see as being illegitimate, let's say. So we can sort of loosely identify consumer protection as being the purpose of the legislation. What's the burden here? Who's impacted and how?
The burdens that falls upon the Queensland company. What was that? Sunshine Unlimited. The burden falls on them having to reshape their packaging to suit the New South Wales requirements.
Yeah, exactly. So and the perspective from New South Wales is that you know, it's you can easily adapt to the presentation of the product, but you know, it's hard to say on the facts whether that's true or not. Arguably any change in the way that the product is presented is a burden, and it's just a question of how significant that is in terms of how much of a change in the preparation techniques, refitting all the machines in the factory or whatever it is, that determines how significant it is. But you know, presumably if it was an easy fix, they would have already done it in order to not lose out on the sales. So I think reading on the facts, we could say that, you know, there's a burden clearly, and it's probably not an insignificant one at the very least. Okay, that's great. That's a really good start. So let's now think about structured proportionality. And so this first idea of being, is the legislation suitable? So remembering our purpose is New South Wales customers are expecting margarine to come in cubes. That's an important habit that they need to have protected, apparently. Does the requirement that margarine only come in cube-shaped blocks, is that suitable to that purpose? Is there a rational connection between the purpose and what the legislation sets out?
Yes.
Yep. Yeah, I think that we'd be pretty satisfied of that, right? They're expecting it to come in cubes. The law says it has to come in cubes, right? So that's good. Next step being, is it necessary? Or is it a necessity? Are there other ways in which you could achieve this purpose?
Achieve irrespective of the form of the packaging by, for example, putting the name margarine in a larger font in big letters, which would also prevent confusion among the products.
Yeah, absolutely. I think that's a great point. So, and part of this comes down to the way in which, or the level at which, we understand or argue about the purpose. If we take the surface level purpose as, or the higher order purpose as being, we just want to protect the consumer and prevent confusion between margarine and butter, I think we'd have a really rock solid argument here to say there are easier or less burdensome ways of achieving that end. And it's just a matter of, sorry, I just got the thing in the chat that I'd frozen. It looks like I might be back though. So I think you're right. If we're arguing that the higher order idea is whether or not there's trying to protect against confusion, there are much less burdensome ways of achieving that. as you say, just make it really clear on the packaging. This is margarine. This is butter. But if we understand it as New South Wales people, this is where we get a bit of federalism and tribalism and good-natured poking fun at other states. People in New South Wales can't read. They only can identify margarine by the fact that it comes in a cube. So the protection, the purpose needs to be to protect this kind of cube shape, because that's the habit that consumers have gotten themselves into. Then I think that argument becomes a little trickier. I think it's still there. I think that you could still say that there are reasonable alternatives, but it becomes more difficult, and there is a strong counter argument, which is that if consumers need to be protected by having cube-shaped margarine, then the only way that you can achieve that is by requiring margarine to come in cubes. So let's, for the purposes of pressing on with the question, let's say that that's the direction it goes in, and that is reasonably necessary, or it's a necessity, I should say. But I think actually, you'd have a solid argument against that. The third thing then is to think about whether it's adequate in its balance. Does the requirement that margarine comes in cubes to protect consumers, does the burden, is the burden that puts on interstate sellers of margarine or manufacturers of margarine, does that outweigh the benefit that comes to people in New South Wales being able to buy margarine in the way that they're expecting to? Or maybe to rephrase that, or think about it in another way. Does the benefit of protecting consumers in New South Wales, how does that compare to the impact that this legislation will have on interstate manufacturers?
I think that it's too unreasonable to change packaging for the benefit of New South Wales, if that's the way we're going in line with this question now.
Okay, so the idea that it goes too far, it doesn't.
No, I don't. Like, if we're looking at it for the absolute benefit of the state, and there's no way around it now, and that we're looking at it if it's an unnecessary burden on other states to trade with New South Wales, I think that the changing of packaging for such small products, this is how I define it, is not unreasonable to ask it to be shaped in cube-shaped products then. Firstly, I would have said it would have, going back to the whole thing of us living in New South Wales, even though we're illiterate, maybe we could change the colours on the packaging so we could understand it. But
okay,
But looking at it from that perspective, since we've now defined that, yes, it must be a cube, do we think it's an unreasonable approach for other states? They're not limiting trade with New South Wales or stopping trade. They're just saying that this is the protection we've enshrined in since we've started trading, and we want to maintain that. I don't think it's a big burden then change your packaging.
Okay. Yep. So it's so if you were a judge in this case, you would have found it problematic at an earlier step in structured proportionality, but
I'm a little bit behind on the reading, but I'd have gone with the TUI's approach, probably the Castlemaine TUI's, and said that, shapes in bottles, as you mentioned at the start, should not be defined to that one state, where I'd allow the different shapes of the butter and the packaging, knowing that butter is absolutely not that dangerous of a product that it requires safeguarding, or else it'll be sold in the chemist. So, I mean, we should be able to rejig the packaging. And then I
Okay.
thought about Bata, where they looked for their intellectual property, I think it was, to change the packaging on the front of the cigarettes as well, as to that the High Court upheld that they should be disclaimers on there.
Okay. Also, that's the BATA case is a bit different because that's looking at acquisition of property. So that's I can sort of see where you're going with that in terms of it's thinking about
The branding,
how
sort of
things are
brand of it.
packaged and how things come. But what I think what your answer does is it highlights the way that structured proportionality, they're introducing structured proportionality as a method rather than the previous approach, which was set out in Cole and Whitfield and then applied through Castlemaine Tuohy's, the Betfair cases, those sorts of things. Shaking up the order in which we're thinking about things potentially shakes up the conclusion that we arrive at. Sometimes it'll be the exact same, but where we're in Castlemaine Tuohy's and in Cole and Whitfield, we're thinking about firstly, does it discriminate? Yes or no? Secondly, is that discrimination for a protectionist purpose or for something else? And then thirdly, is that if it's for a non-protectionist purpose, is it reasonably necessary? I can see why following those steps, you get to the conclusion that you do in the order that you get it in. Whereas structured proportionality flips it, and we're identifying the purpose first, and in doing so, that then filters through to the way that we understand and apply the rest of the structured proportionality method. And so the level at which we're identifying that purpose, is it to protect people in New South Wales from understanding the difference between butter and margarine, or is it to protect this cube, this cultural habit, this New South Wales quirk that needs to be protected and preserved as a matter of state identity? The level at which we understand the purpose then informs the way that we understand whether it's suitable, whether it's necessary, and this is where Vladislav's arguments were coming in as well around, how far should New South Wales be throwing its net in this issue, those sorts of things. But having defined at the start what the purpose is, by the time we get to the end, by the time we're getting to this idea around is the law adequate in its balance, we're getting to the point that the conclusion might well be, as you say, that in this instance it is adequate in its balance, whereas if we applied the method from Cole and Whitfield, you might be reaching the conclusion to say that, well, it's not reasonably necessary or it's not appropriate and adapted. So really highlighting that these approaches can lead us to different conclusions, even though it's the exact same set of facts, and it's potentially the same ideas or the same issues that we're raising. Just changing the order and the emphasis of them potentially leads us to different conclusions. Vladis, I saw you had your microphone off. Was there something you wanted to add there?
Yes. Well, in my case, I would argue in both ways, in the way you've just described, and in the way that there is no difference between the market trader, whether they're New South Wales ones or from Queensland, the overall prescription, the overall mandatory rule is to have this packaging in a cube form. And we have here the clear indication: imported, held in stock, exhibited for sale, delivered. All this applies equally to interstate and intrastate. However, the peculiarity here is that the license may be granted if margarine is imported from other states in other than cube shape. So if this is the case, this would put the exporters from other states in a favorable position against New South Wales margarine producers. And in that sense, it will be discriminatory. So the exporters from our other states will gain an advantage over New South Wales traders by having this possibility of being exempted from this requirement of a cube shape.
Yeah, that's a really great pickup. The difficulty is there's two parts. The first might be that it's possible on these facts, given that the sale of margarine in cube is rooted in the habits of New South Wales or whatever. It's possible that all the New South Wales manufacturers are doing it in cubes anyway. But equally, I'll say it's possible that they're not, and therefore a New South Wales margarine manufacturer who's putting their margarine in prisms or spheres or something, potentially they're disadvantaged by this as well. I think you're absolutely right.
From the procedural point of view, they simply don't have right to apply for such kind of exemption.
Yep. The difficulty is if they're manufacturing in New South Wales and they're selling in New South Wales, and so being captured by this legislation, they're not engaging in interstate trade or commerce. They're only engaging in intrastate, so within New South Wales. And so in that sense, they're not engaging in interstate trade or commerce, so they're not being protected by Section 92, which only applies to interstate trade and commerce. So I think it's a great pickup and great attention to detail, but it wouldn't, and to frame it in the language of Colin Whitfield as well, it's potentially discriminatory, but it's not protectionist because it's not protecting New South Wales manufacturers, as you say. In that instance, it's actually harming them. It's doing the reverse of protectionism. So I think it's a great pickup, but it wouldn't affect the way that we're analyzing this particular issue.
Well, it will lead to the same result. The law is invalid in that sense, but the argumentation is different. The conclusion is the same.
Well, no, that's what I'm saying though, is that it wouldn't. If the law in practice disadvantaged New South Wales manufacturers, it wouldn't be a discriminatory burden of a protectionist kind to follow Colin Whitfield, or to use the language of Section 92, it wouldn't prevent interstate trade and commerce from being absolutely free, and so it wouldn't be imposing a burden on free interstate trade and commerce. So it wouldn't be invalid on those Section 92 grounds. So the conclusion potentially would be different. But that's all right. So thinking about, just to wrap up, because we're running out of time. Under the structured proportionality test,
product into New South Wales, is that correct?
Sorry, I must have frozen there. I missed the start of that question.
So I was just wondering, this kind of legislation is just not for the Queensland manufacturers. It's the other state manufacturers as well. It's just trying to bring uniform between the product in New South Wales.
I'm not sure I understand the question. So it's a law that applies to the import and sale of margarine within New South Wales. And so if you're an importer, it potentially affects you. And it potentially affects people from all over Australia, not just Queensland. You're right in that regard. Is that the question?
Yeah, that's right. So that means that there's no discrimination just on the Queensland manufacturers. So it's any other state bringing product into New South Wales has to follow the standards. So I find that the law is like a standard and a uniform. So there's no discrimination here on this part.
Yeah, so there's no discrimination singling out a particular state. It's a law of general application. What the argument potentially is that if people in Queensland or wherever else could easily adapt their the way that they manufacture their margarine, if the cubing margarine's deeply rooted in New South Wales sale of margarine, and all the New South Wales manufacturers are already doing that, and yet people from other states are having to change their methods, then they're suffering a burden. They're having to change their practices in a way that the New South Wales manufacturers aren't, and so it's not discriminatory in the legal wording that's used, but in effect, it introduces discrimination because it's imposing a burden in effect on other states, but not New South Wales. So just to sum up, under structured proportionality, we'd probably have a good argument to say that it's suitable. There may be issues with necessity. I think we could challenge the legislation on the ground of necessity. If it were found that it was necessary, we then look at whether it's adequate in its balance. I think you could argue either way, and it really depends on exactly how you've characterized the purpose of the legislation at that point. And so getting to that third stage of the structured proportionality test, you could argue it either way, and I feel like both outcomes would have a good argument. On the Cole and Whitfield approach, is it discriminatory? Yes. Is it for a protectionist purpose? Arguably it is. What's crucial to think about is that protectionist is about protecting business or preserving economic advantage for, in this case, New South Wales businesses. The idea of consumer protection isn't in itself protectionist, even though there's a similarity in wording. But so what we'd be thinking about is, is the purpose of the legislation to protect New South Welsh businesses? On the words that New South Wales uses, it's not. The purpose is for consumer protection and preserving these habits of New South Wales customers. And so arguably it's got this other purpose that might be legitimate. And then we're thinking about, is that reasonably necessary or not? And then I think we can argue that these issues around, does it have to be in a cube? Could you use other packaging methods? Could you explain the difference in a different way? All those sorts of arguments come to the fore. But because that's coming in at the last step, we'd expect that those arguments do actually become a little bit stronger. So again, I think you could go either way, but you'd have a stronger argument to say that the law does impose a discriminatory burden of a protectionist kind, and therefore would be unconstitutional, incompatible with Section 92. I'm conscious that we've gone over time, but are there any last questions about that that hypothetical?
I'm just thinking from hypothetical scenario, maybe the New South Wales government wants to differentiate between the products coming from interstate so that the consumers can easily identify if it's a cube, it's coming out from interstate. That could be the reason, and that could be a protection given to the in-house manufacturers in New South Wales. That could be another reason too. But I just don't see a point. If they want to make a uniform one, they're not making for the manufacturers in New South Wales same standards, but that could be a argument point. That's what I think about it.
Okay. Yep. Yeah, that's fair enough. We do have question 2 as well. They're a little bit more straightforward. We're thinking about acquisition of property on just terms. The very brief answers to those would be part A, it is an acquisition of property. Presumably it's on just terms if there's a purchase, but there might be an issue with whether it falls under a constitutional head of power or not to be able to make that law. It could go either way. B, the issue here is that the land is to be used outside the Commonwealth's enumerated heads of power, and so that would be a problem. And then C, Commonwealth legislation directing an interstate trader to sell his products to another private trader. Arguably the concern would be that there's not been an acquisition by the Commonwealth, and so that legislation is potentially problematic as well. But if you've got particular questions about those 3, please do feel free to send me an email or make a post on Teams. Thank you all very much for coming along tonight. We'll leave that there, but very happy to keep that conversation running in Teams over the next few days. So we'll see you all then. Thanks very much. We'll see you next week to talk about implied constitutional rights. So see you then. Thanks very much.
Thank you.
Thank you.
Thank you.